We'll begin with Doriane Coleman from Duke University.
Hi, everyone. Thank you so much. Just as cells are permeable so that infectious disease can move from cell to cell and spread within our bodies, so too our bodies are permeable so that disease can move from individual to individual and spread within our communities. In the face of infectious disease, it therefore makes sense to be communitarian, or at least to privilege our communitarian instincts. This means vaccinating to achieve herd immunity. This principle is deeply embedded in our most basic law, which authorizes the government to impose otherwise abhorrent restrictions on liberty, including mandatory vaccination in epidemic conditions. The court's 1905 decision in Jacobson versus Massachusetts remains the only case squarely to address the constitutionality of a local vaccine mandate. In Jacobson, the court rejected petitioners' argument that individuals have a substantive due process right to refuse their consent in circumstances where local authorities have concluded that universal vaccination is necessary to protect the public health. The court held that the city of Cambridge could require all healthy individuals to be vaccinated against smallpox. Since Jacobson, the court has decided only a handful of cases touching on vaccine mandates, none of which questioned its conclusion that liberty can be significantly ordered in the face of infectious disease. Two of these, Prince versus Massachusetts in 1944 and South Bay United in 2020, suggested that the outcome would not be different in cases involving religious liberty rather than substantive due process claims. We're likely to see this assumption challenged in the context of any COVID vaccine mandates that don't include religious exceptions. Jacobson itself will be at issue, and it's certainly possible that the new composition of the court will affect its outcome. We got a hint of this over the summer as Justices Alito, Thomas, and Kavanaugh, writing in dissent in Cavalry Chapel, Dayton Valley, cautioned that it is a mistake to take the language in Jacobson as the last word on what the Constitution allows public health officials to do during the COVID pandemic. When that challenge comes, Jacobson should nevertheless provide substantial guidance. As the court suggested at the end of that opinion, the question should be whether it would be easy enough to accommodate religious freedom claims without harming either the right of other individuals to be free from disease or the public interest in establishing the immunity of the herd. If it would be easy enough, on Jacobson's rationale that in a community committed to liberty for all, general terms should be so limited in their application as not to lead to injustice, oppression, or an absurd consequence, we should endeavor to do so. This is because state laws that allow for religious exceptions to vaccination requirements make sense for everyone. For religious people, exceptions are justified by their convictions. For everyone else, they're justified politically by our social compact and the harm principle. Freedom for others is the price we agree to pay in exchange for our own, and exceptions do no harm so long as still susceptible individuals can be protected and herd immunity can still be achieved. According to the operative communitarian principle, both religious exceptions and law reform that would restrict them are not only constitutional, but also on sound moral and political ground when they hew closely to these justifications.